Good afternoon. I'm Judge Leslie Kim Smith. We are now live streaming on YouTube and on the record. Calling case number 23005640 NI in the matter of Murad Ahmed versus Auto Owners Insurance Company / Homeowners Insurance Company. Counsel, will you place your appearances on the record starting plaintiff's counsel?
Yes, Your Honor. Ryan Van Stone on behalf of Mr. Murad Ahmed.
And good afternoon.
I'm sorry,
Oh,
Mr. Beagle is also here. If you want to just put your appearance on the record.
Joshua Beagle on behalf of Plaintiff Murad Ahmed as well. Thank you, Your Honor.
Thank you.
and Ross Janicek here for defendant auto owners / homeowners, Your Honor.
All right. This is the date and time the court is going to render a decision on plaintiff's motion for no fault attorney fees. The last time the matter was before me, I did ask counsel to provide the court with a payment log. I did in fact receive the payment log. Is there anything, Mr. Van Stone, that you'd like to supplement your oral argument just based on the document that that the court received?
Yes, Your Honor. I'll just note that in supplementation, given that submission, if we're speaking specifically to unreasonable claims handling, that the matter itself, the jury, after hearing the adjuster's deposition and the testimony and the alleged surveillance, did feel that warranted was penalty interest. And in addition to that, they tended to agree with Dr. Teresa Oni, the defense's expert, who said my client was injured and required treatment, and they chose not to listen to that. And they did make some payments, but they did not listen to their own expert. It wasn't the jury disagreeing with their experts and agreeing with ours. It was more so the fact that the insurance company's own expert, who's who they ultimately agreed with, and the adjuster made a mistake in unreasonably handling that claim, despite making some payments, just not all.
All right. And Mr. Janicek, is there anything that you wanted to add?
No, Your Honor, I think I've already addressed those same points in the prior oral arguments.
All right. May the record reflect, I've had an opportunity to listen to oral argument and review the pleadings as well as review the supplemental exhibit that was presented, which was the payment log. Plaintiff filed this action on May the 3rd, 2023, seeking first-party no-fault benefits from defendant Auto Owners Insurance Company, which is later known as Homeowners Insurance Company, arising from the motor vehicle accident that occurred on October the 6th, 2022. The case went to case evaluation on April the 8th, 2024, but it did not resolve the case. In December 20th, 2024, the parties were ordered to facilitate, and the case was scheduled for trial for May 12, 2025. On February the 10th, 2025, the case was reassigned to this court by way of a docket directive. The case proceeded to a jury trial on May the 12th, 2025, and on May the 15th, 2025, the jury rendered a verdict in favor of the plaintiff in the amount of $98,942 in allowable medical expenses and $11,873.04 was awarded to the plaintiff for penalty interest. Plaintiff filed this motion for no fault attorney fees, prevailing party costs, taxable costs, and entry of final order. However, it should be noted that a stipulated order was entered by the parties or by the court on January the 20th, 2023, that resolved the issue as it relates to prevailing party cost, taxable cost, and entry of final judgment. So therefore, the only remaining issue is whether or not plaintiff is entitled to no fault attorney fees. On this issue, plaintiff argues that the jury awarded penalty interest and that defendant cannot rebut the presumption of unreasonableness. Therefore, plaintiff would be entitled to attorney fees under MCL 500.3148 subsection 1. Defendant in its response argues that plaintiff claimed $235,000 at the time of trial, and the verdict was a fraction of that claim. Defendant also argues that $122,000 was the claim for wage loss, replacement services, and intended care, which was dismissed by plaintiff on the eve of trial. Defendant's delay and/or refusal of making payments was based on numerous bona fide factual uncertainties. And it goes into a list of what defense counsel believes are the factual uncertainties. Under MCL 500.3148 subsection 1, it provides that an attorney is entitled to a reasonable fee for advertising and representing a claimant in an action for personal or property protection insurance benefits which are overdue. The attorney's fee shall be a charge against the insurer in addition to the benefits recovered if the court finds that the insurer unreasonably refused to pay the claim or unreasonably delayed in making the proper payment. When benefits are overdue, the penalty interest is owed. It's a rebuttable presumption of unreasonable, and the insurer has the burden to justify its refusal or delay to make the payment. To justify a delay or refusal, an insurer must proffer and establish a legitimate question of statutory construction or constitutional law or a bona fide factual uncertainty. In this case, there's no dispute that payments were made, and according to the payment log, there was at least $28,000 paid, not only as it relates to the wage loss claim, but also various providers, including Right Way Rehab as well as Carl One. The court finds that the defendant has established a bona fide factual uncertainty that justifies the delay or denial of the payments. Plaintiff claimed a right shoulder pain at the time of the accident, which was October the 6th. There are discrepancies that exist as to how plaintiff was referred to Carl One and Right A Rehab and to Dr. Calloway. Plaintiff's brother-in-law, a radiologist in Florida, prescribed physical therapy, which is contrary to the medical records in the Right Way Rehab. Also, defendant has provided video showing plaintiff limping to go into an IME exam and later not limping, but more importantly, showing plaintiff working behind a counter at a convenience store while making a claim for wage loss. There was an IME finding no objective evidence of any injuries by Dr. Miles Singer. The PIP benefits were terminated by the defendant on April the 14th, 2023. Again, based on the evidence presented, it's clear that there was a bona fide factual uncertainty. Therefore, plaintiff would not be entitled to no-fault attorney fees under the statute. Okay.
Thank you, Your Honor.
Thanks,
All
Your
right. If there's nothing else,
Honor.
matters adjourned. Have